Sorry for the delay. Yes.
Take the 54 order will show. So there's a nuanced interpretation of 370 that would my lords be kind enough to turn to documents volume 3, PDF page 13. Let me, let's preface my submission by saying this, that there were substantive provisions of the Constitution of India that were to be made applicable to Jammu and Kashmir, the directive principles of state policy, or even 356. These were all done through the application order. So that's the power under D, with concurrence. Take fundamental rights. That's nothing to do with the lists, Manoj. With 371, B1 and 2 talks of the lists. By law, particular lists. Instrument of accession, only those 4 items. That's B1. B2, other lists. That only refers to lists. That's 370. Then you come to Mallards, the application of constitutional orders to Jammu and Kashmir. Now, where any law passed under the lists, if it relates to Mallards, instrument of accession, consultation. If it relates to other things, concurrence. But substantive provisions of the Constitution were made applicable, Mallards. That also with concurrence. And this was being done between 1951 and 1957, when the Constitution came into force. Then the Constitution took over.
This was between 1951 and 1957.
After that also there were application orders. Because 371D, Mallards, continued in operation. So that's why I want to show you the 1954 constitutional order, which superseded the 1950 order. And it will show Mallards what was done. So nothing was ever done without concurrence, except Mallards for those 4 items. Never. Till date. So now kindly see page 13. PDF 13, volume 3. Documents, Mallards. Volume 3, PDF 13.
Page number?
Page 13, Malad. PDF page 13. Running page 406, Malad.
14th May notification?
Yes, Malad, yes. Now, kindly see, Malad, by this time the constitution is not in place. But they have superseded the 1950 order. So all orders hereafter were with respect to 1954 constitutional order. Because 1950 was superseded by 1954. So every other order was under 54. Now let me just show that to your lordship. The following order made by the president is published for general information. The constitution.
Just 1 second. I just need only 1 minute to
I'm sorry.
get back.
I'm sorry.
I was focusing on something in the constitution. Which volume would you?
Volume, documents, volume 3, PDF page 13.
Yes.
What has it? Says the Constitution application to Jammu Kashmir Order 1954 in exercise of the powers conferred by Clause 1 of Article 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, is pleased to make the following order. The order may be called the Constitution application to Jammu Kashmir Order 1954. It shall come into force on the 14th of May 1954 and shall thereupon supersede the Constitution application to Jammu Kashmir Order 1950. Now see what happens thereafter. The provisions of the Constitution, which in addition to Article 1 and Article 370, because that's Clause C, Malad, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall apply shall be as follows. Now, preamble. That's the power under D. In with concurrence. So, Malad, you see part 1 to Article 3, there shall be added the following further proviso. Provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. Now, this is passed by the constitutional order applicable to Jammu and Kashmir. That's the solemn promise, Malad, that has been made, that you will not change the boundaries. And that's with concurrence. And that's exactly what they did, without concurrence.
Mr. Sibal, why is it that, what is the distinction between the consultation with the government of the state, which is referred to in the first proviso to D, and in clause 1 of B? Because clause 1 of B also refers to consultation with the government of the state, and the first proviso to D also refers to consultation with the government of the state. So it can be a surplusage. There has to be a meaning for why there's two separate provisions in relation to the same.
I must explain that. I must explain that. Because if you look at Malad's B1, it says make law. It's not in relation to the same thing. So it says make law with respect. So it only deals with the lists. If it comes to instrument of accession, those 4 items.
Actually, I was looking at it this way, possibly. I mean, just thinking aloud, maybe wrong, correct me if I'm wrong. B1 refers to the specification of matters,
yes,
on which are covered by the instrument of accession,
yes,
in respect of which Parliament can make laws. That is B1.
correct.
It refers only to the specification of matters in the union list, which are covered by the instrument of accession, on which Parliament would have the lawmaking authority. That is B1.
Absolutely.
Now, the first proviso to D would obviously not cover that category. Otherwise, there was no need to put the first proviso there.
Well, those only.
Just see, just one second.
I'm sorry.
See, the first proviso also says, provided that no such order which relates to the matters specified in the instrument of accession of the state referred to in para 1 of subclause B shall be issued except in consultation with the government of the state. So the first proviso also refers to the matters covered in clause 1 of B. It also refers to consultation, and B1 also refers to consultation. Now, possibly the meaning which can be attributed to the proviso to D is this. D says, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may make. So, where the president is making an exception or modification to another provision of the constitution, then the president has been given the power. But what the proviso says is, the first proviso says that if the president is making a modification or adaptation in respect of a matter which is referred to in clause 1 of B, namely something covered by the instrument of accession, then you require consultation. The second proviso then says that no such order which relates to matters other than those referred to in the last paragraph will be made except with the concurrence. I was wondering, just thinking aloud, what D says is that if the president is making an exception or modification in the application of any provision of the constitution to the state of Jammu and Kashmir, then you require either a consultation, first proviso, or a concurrence in terms of the second proviso, right? Now, what happens if the president is not making any exception or modification at all? Does that require either a consultation or a concurrence?
Yes, Manoj, according to me, yes, but let me explain.
Because this adaptation order which you showed us, for instance, of 1954 makes modifications. Preamble will apply subject to these exceptions. Directive principles will apply subject to these exceptions. But what happens if the president is not making any exception or modification at all? Then do you require a consultation or modification in terms of clause D?
May I, Manoj, then?
Yes.
On Manoj, since you're
Yes.
Now, Manoj, kindly look at B1 first for a minute. It says the power of parliament to make laws for the said state shall be limited to matters in the union list and in the concurrent list. It doesn't say anything more than that. It specifies the lists under which they can make laws.
Which?
Again, no, that's right. The law has not yet been made. It's only the power.
Are declared by the instrument of accession.
So, Manoj, only the list, communication.
Right.
I'm not talking about, the law has not yet been made.
No.
So they are correlating the making of the law to the items in the lists. When it comes to the instrument of accession, it has those 4 items. When it comes to other matters, it is in the concurrent list, not in the state list. But they are not setting out, Manoj, what law is to be.
One very important thing is that clause B does not confer the power upon parliament to enact law for the state of Jammu and Kashmir. It limits it in certain respects. The power of parliament to enact law is under 245 and 246.
246 will not apply.
No, but the power is somewhere else apart from B.
No, Manoj, I'll come.
B recognizes the power of parliament to enact a law because it says the power of parliament to make laws for the state shall be limited. It's a limitation.
No, it's a limitation.
But Justice Paul also says that it's a limiting clause.
Yes, square that list only means square that list.
So if it is a limiting clause, the power of parliament to enact the law is traceable elsewhere.
No, Manoj, Manoj.
Can we say that 370B gives power to parliament to enact law? No. It limits the power of parliament to enact law to a certain extent.
I was trying to explain what
Yes.
Lord put to me. Please allow me.
Yes.
What I was trying to say was that here, what the clause says is that where the lists in the instrument of accession, right? Parliament may make a law, but that will be in consultation.
It's a double limitation, Mr. Sabul. See, the first limitation is the chief mentioned,
And let's
power
leave
of
it-
parliament to make laws for the state shall be limited to.
Yes.
What is it limited to? To matters in the union list
Yes.
and concurrent list. So first part is matters in union and concurrent
Correct,
list.
correct.
But second qualification, which in consultation with the government of state, there also you are right, to that extent you are right, it is in consultation with government of state, are declared by president to correspond to matters specified in the instrument of accession
Correct,
governing the accession of the state.
correct.
So such parts of union list and concurrent list, which form a part of the instrument of accession,
Correct.
because everything else doesn't form a part of instrument of
Correct.
accession. The whole list doesn't.
Right.
To that extent, Parliament can enact,
Law.
Parliament is limited to enacting laws in respect thereof in consultation with the government.
Absolutely right.
That's
No,
how I
no,
read it.
not, that's what I'm saying too. But they are not, at that moment, the law is not made. They are only saying the contours under which Parliament will enact a law. The contours with respect to instrument of accession are those four items: communications, defense, external affairs, and ancillary, which I showed to your lordship the schedule. When it comes to B2, the contours again of the items in the concurrent list over Parliament may make laws. Again, it doesn't say that law is made. It only delineates the contours. Therefore, I'm going to now distinguish it from D, Malad. That's how I'm going to.
Let's come to D. How would you?
I'm just coming.
Yeah.
Then you come to see the provisions of 1 and of this article shall apply in relation to that state. That's not covered. That's not covered.
Right.
So that's Malad's. 1 is integration into India. And Malad's, the other is Article 370. Now come to D. Such of the other provisions of this constitution. Now we are not talking about lists. Now we are not talking about lists. We're talking about preamble. We're talking about 356. We are talking about fundamental rights. Each of those orders require the concurrence of the state. I'll show that to your lordship. Here it is such of the other provisions of this constitution. 371B doesn't talk of any other provisions of this constitution. It talks of the instrument of accession and the concurrent list, the contours of the power. When you come to other provisions of the constitution, these may be made applicable. That's why the order. Now let's read it further. Such of the other provisions of this constitution shall apply in relation to the state, subject to such exceptions and modifications as the president may order set specify, not referred to 371B. There's no order, no question of order there. It's only the contour of the power. Now read, provided that no such order, that is no such order relating to D, which means provisions of the Constitution of India to apply to Jammu and Kashmir. No such order which relates to matters specified in the instrument of accession referred to in paragraph 1 of clause shall be issued. Kindly note the word issued. That's the difference between 371B and 371D. Because no orders are issued under 371B.
That's the power to make law.
That's only the contour of the power. Your lordship asked me the difference between the two. I'm just trying to advance an argument with respect to the difference. It's
Yes,
entirely different.
Yes, ma'am.
Yeah. Yes.
So, Attorney General, that two constitutional practice is one thing. We are now looking at just the text of the provision. There are two possible constructions of Clause D. Constitutional practice may seem to support what Mr. Sibal is saying. One is that D refers to the fact that other provisions of the Constitution may apply such
Other than one and
two. Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. In other words, if you are making exceptions or modifications, that's one construction. That if the President is making exceptions or modifications, then if it relates to a B1 subject, then you require consultation with the state. If it relates to something other than a B1 subject, you require consultation of concurrence of the state. All right? So it is only where you are making exceptions or modifications in the Constitution that it requires either consultation or concurrence. The other interpretation is that even if you are not making any exception or modification, but you are making some provision of the Constitution applicable to the state of Jammu and Kashmir, you still require either consultation or concurrence, even if you are just bodily lifting it and making it applicable without exception or modification. That's the second construction of D.
That's correct.
Now, the question is really which is a more plausible construction.
I can do that. Because actually, if your lordship looks at the 1950 order itself, it will give an indication of what was meant. And just not leave 54.
That's why, Mr. Sibal, the Chief Justice, the constitutional practice does support this view, but there are two plausible constructions which can be made. One is that the entire Constitution has been adopted in terms of Clause D. If you require modification or changes in that part, then you require a presidential order which shall be issued in consultation, not in consultation, with concurrence of the state.
I appreciate that, but that will render three OCOs completely. C will become OCOs.
C is
the provisions of the
The
Constitution.
C is something different. C dilutes the article itself.
C, Madhur, I am not on anything else. When you see other provisions of the Constitution, except for one and the 370, you can't touch 370. But let's move forward, Madhur. I'll be able to show that to your lords.
P is 370 and C is Article 1.
And one is Madhur's integration.
Integration.
So that can't be touched. Part of India can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched. C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched. It doesn't say it can't.
By now, your lordships have, in fact, Madhur, may I tell your lordship something interesting? Because I looked at the original Constitution of India. Learned friend will show it to your lordship. It was only a marginal note. It's not the heading of 370.
It's a marginal note, absolutely. No doubt about it. It's a marginal note.
It's a marginal note. And your lordships have held in Keshavanam Bharti itself. Can't look at these notes.
No, in the sense that a marginal note doesn't control the meaning of the text.
C and 3, Article 3. You can't. A marginal note can't say it is temporary, therefore I read this in this fashion. Can't be done. Anyway, after that one, let me Madhur, show you. It's
Yes,
very
again,
fascinating.
yes.
But I take a bit of time. Well, let's kindly come to 370 presidential order.
That 1954 order.
1950.
Let's have a look.
50. Same volumes.
1950 or 54?
No, Malas, I'm coming to 50, Malas. Liquid text. Volume 3, PDS page 4, Malas.
This is what you were reading as 13. No,
No,
something.
that is the 54 order. I'm coming back to 1950 order, which was superseded by the 54 order.
This is where?
This is PDF 4 in the same volume. Malas. The other was on at 13, this is at 4.
This is at 4.
Yeah.
Are you
Kindly
referring
see.
to CO number 10, Mr. Sibal?
Yes, absolutely. Well, let's kindly see the index of this. 3 pages earlier. Yes. See what has happened. This will give you the kind of orders that have been passed from time to time. There are, by this time, about 54 orders. These are probably not all the orders either.
Very first page of the volume.
Yes, yes.
The first page of the volume.
That's right.
We are looking at
There's a whole
different
index of all the orders.
orders issued.
Yes.
Serial number 1 was superseded by serial number 5.
To specify.
Now read it with me. The order may be called the Constitution Application to Jammu Kashmir Order 50, which should come into force for the purposes of subclause B1 of clause 1 of Article 370 of the Constitution. The matters specified in the first schedule to this order, being matters in the union list. This is in consultation. Kindly read the words. In exercise of the power of 370, in consultation with the government of the state. For the purposes of B1 of clause 1 of 370, the matters specified in the first schedule to this order, being matters in the union list, are hereby declared to correspond to matters specified in the instrument of accession, governing the accession of the state of Jammu Kashmir to the Dominion of India as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for that state shall be limited to matters specified, which your lordship said is the limitation. Rightly said. Now come. In addition to the provisions of Article 1 and 370, again, of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to this order, and shall so apply subject to the exceptions and modifications specified in the said schedule, and the modification of that all references to the said provisions shall be construed as reference to the Sadre. This is applicable to D. First schedule deals with entries, and this deals with D, because you're not to apply now the provisions of the Constitution of India, and they are all incorporated in the Constitution of India as applicable to Jammu and Kashmir order. So 356 also comes there, Part 3 comes there, Preamble comes there, Directive Principles of Policy come there, but that's all with concurrence. Therefore, it didn't come at this stage. That happened later. Then you went, then now kindly see the first schedule you have seen. These are those very entries that we were talking about. And kindly see the second schedule. It starts, at PDF 6, page 17. Just for my lord. PDF 6, page 17. Kindly see exceptions. Article 72(1), provisions of the Constitution applicable. So there was no doubt on this issue, Malad. Entirety of Part 5. Part 5, 72, 1C, 72, 3, 133, 134. Those are exceptions. Last column is modification. So it's not just a question of application. It's a question of substantive understanding of what 370 is. Even if you want to apply a provision without modification, you need consultation with respect to or concurrence. You can't. There is no third way of doing it. Yeah, that's excluded anyway. I said that we've given the examples. Modifications 54 and 50 shall apply subject to modifications that the reference therein to the elected members of the Houses of Parliament to each elected member of either House of Parliament shall be deemed to include respectively a reference to the representatives of the state in those houses and to each such representative. So you modify. 54 and 55. Then if 247 you modify. 246 shall apply subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply. So you can't pass a law.
So what is the effect of clause 2 and 3 of article 246 not applying in relation to the state?
Because the residuary power is with the state.
No, but 246(2) refers to the power of parliament and the state to enact laws on the concurrent list.
That's fine.
No, but if 2 is not applicable, then neither the state nor the parliament can enact a law on the concurrent list.
It will be because of 1B, Malaz. It only tells you the methodology, Malaz, that's all. The point is, what my lord is putting to me is, the president can exercise powers under 370, dehors a modification. That's an exercise of plenary power. That's what my lord is putting to me. But Malaz, this clearly shows that even that exercise has to be done with concurrence. If it relates to the concurrent list, and consultation if it relates to instrument of accession, can't be done any other way. So it's not a matter of practice alone, it's the substantive interpretation of 370. Kindly see the first column, Malaz. All the articles apply. Part 9, Part 11, Part 12, Part 15, Part 16, Part 17, Part 19, Part 20, everything applies. But in those parts, there are exceptions and there are modifications. That's set out in the third column. Nobody disputes that. The whole part applies.
Clause 3 of the order seems to suggest that the only provisions of the Indian Constitution which would apply to the state of Jammu and Kashmir are those which are specified in the second schedule, and that too with the modifications which were made.
Absolutely. That's our submission. And then this is superseded by the 1954 order. For example, Part 3 at this stage was not to apply. It's not in the second schedule.
Let's go to this now the
54 order.
54 order.
Yeah, that's volume 3 again, page 13. That's it. 13 PDF. Yes. Yes. In exercise of the powers, you also have that? So exercise of the powers conferred by clause 1 of 370, President with the concurrence of the government of the state of Jammu is pleased to make the following order. The order may be called the Constitution Application for Jammu and Kashmir Order. So, Malaz, supposing the entire constitution was to be made applicable, Malaz, it would require concurrence, no? Only some are applicable, some are not yet applicable. You will see that 356 comes later. 356 doesn't come at this stage. That would also require concurrence, and concurrence was taken. So, any provision of the Constitution of India which relates to the concurrent list would be made applicable subject to the concurrence of the state government. Consultation and concurrence, instrument of accession and concurrent list. And Article 1 and 3 are out of it. So kindly see, Malaz. Clause 2, the provisions of the Constitution which in addition to Article 1 and 370, in addition, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows, the same pattern.
So the exception made here is the entire constitution is adopted subject to the modification made there. Unlike
other
the
than 1 and
1950.
3, other than 1 and 3.
1 and 3 is already there.
That's right.
Unlike 1950 order, which had specific articles were made applicable. Now the entire constitution.
No, because 356 was not applicable at this.
No, but there would be a clause in this saying three
It's
fifty-six.
part by part, not true, Malas. Part by, see part 1, no, part 2, part 3. It's part by part. It's not all.
Is 356 specifically excluded
No, at this
in
stage.
this, at this stage?
Yes. Excluded.
It would be excluded at
After
this.
part 5, you have part 9.
Yes, come to page 15, 356 is excluded.
Yes.
So
at
the
this-
entire constitution was made applicable by the 1954 order,
Malas, it said,
except to the extent of exclusion.
Malas, this part 5 is state 11 straight away. There's no question of the entire constitution being included.
Just 1 minute.
Mr. Sibbal, my learned brother may be, if with respect, right. I'll tell you another reason. I'll give you another, just apropos what fell from Brother Sanjeev Khanna. Just see now part 3. First, we'll just see one small provision, clause 2 of the order of 1954.
Correct.
Yes,
It says the provisions of the Constitution, which
yes.
in addition to Article 1 and Article 370 shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications shall be as follows. Now, one thing is very interesting. The word only, which we found in the 1950 order, has been deleted in the 1954
Right,
order.
Right,
So only goes.
yes.
Now, let's go to part 3 for a moment, and just to test the hypothesis.
We'll just go to parts. Yes.
Now, just see clause C in
Yes,
part
clause-
3.
Clause, yes, I
Right?
got it, Malas.
It says in clause 3 of Article 16, the reference to the state shall be construed as not including a reference to the state of Jammu and Kashmir.
Correct,
Now, if we see Article 16(3) of the Constitution,
yes.
it says nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local authority within a state, or any requirement as to residence within that state or union territory prior to such employment or appointment.
Right,
Now, if the entirety of clause 16 were not to apply to Jammu and Kashmir,
yes.
what was the reason for saying that only clause 16(3) will apply subject to these modifications?
For the simple reason that Miller's other clauses in respect of clause 3 of the Constitution came into the J&K Constitution later. And I'll show that to your lordship.
But is it your contention, therefore, that
Entirety of 16
that
applied.
16(1) didn't apply to the Jammu and Kashmir?
It did apply, it applied.
The part which is mentioned.
But how did it apply then?
No, part 3 applies in full. When it says part, your lordship may see they have a serial number and then they have A, B, C below each of these parts. So when they mention the part applies in full. Now, in that part, A, B, C will tell you the exception or modification of the provisions of the Constitution in that part. So when the part is indicated, the part applies in full. In the 1950 order, it was column. So in the second.
That's what I was saying. See, in the earlier, the manner of printing of the two notifications.
Yes,
like
Yes,
this.
that's all,
That's
all.
very good.
In the first one,
Has been
there is a
expressly
column,
excluded.
Yes.
it is a article.
Yes.
Then what is the exception sort of
Correct,
carved
correct.
out?
And the modification, now it's.
Modification exception carved out.
So now
In
it's.
this, the way it is printed as I see it,
Yes.
when they say part 3, it means part 3 applies, but.
But these exceptions and
one
modifications.
column of modifications which were there
Yes.
are specified underneath it.
That's
Exactly.
exactly
That's
what it is,
exactly-
nothing, no difference.
Other than what has been exclusively excluded.
Yeah.
The rest of the part 3 applies.
That's correct. That's all that there is. That's all.
Mr. Sibbal,
Like
I
16,
think,
1 and 2 apply.
Mr. Sibbal, just come to page number, internal page number, the first page, page 10 of the
Page
notification.
10, okay.
The provisions of the Constitution.
Yes.
This means the entire provisions of the Constitution.
Page 10, your lordship's PDF page 10?
Yes,
Yes.
that's the notification, 14th May 1954, 2, clause 2. The
Page
provisions.
13, not 10.
13 of the.
Or page 30,
Yes,
yes,
30.
yes, page
Yeah.
30, you're right. The provisions of the Constitution,
Yes. Yeah.
which in addition to Article 1 and 317, Article 317,
Yes.
because that's covered by
Yes,
3.
yes.
Now, the provisions of the Constitution refers to the entire provisions of the Constitution.
Correct, correct. Yes.
Shall apply in relation to the state of Jammu and Kashmir, full stop.
Yes. Which,
Second-
the word
second-
also left the word out, which.
Yes, I'm aware of that. That second part says, The exceptions and modifications subject to which they shall also apply shall be as follows.
Correct.
So thereafter, the exceptions are carved out
Yes.
with regard to each part of the provision of the constitution, which are either not to be applicable or applicable with modification.
Correct.
And if you go down, it specifically says 356 is excluded.
Yeah.
In case this was specific inclusion, they need not have specified 356 is excluded. Because by implication, 356, if not mentioned in the schedule, would have been excluded.
With the greatest respect, when you say kindly read it, just see. Kindly see part 18.
The very fact that some articles have been
Kindly see
excluded,
page 18. Kindly see page 18. PDF page 18.
yes,
Which is this. See part 18. 352, the following new clause shall be added. Above that,
correct,
part 18.
correct.
And therefore there are exceptions.
We are then at item.
But the part applies, but there are exceptions and modifications.
So like part 18 applies, for example, part 18 applies,
Yes.
the modification is specified below that.
Yeah.
Then small clause B, 13, part 3, small b.
Therefore, there is no dispute on
The
that.
entire constitution has been applied. They would
357.
accept what
Exactly.
So these three articles of part,
Which shall apply shall be as follows.
Will not,
We don't.
that's correct.
Kindly see, and also it says the provisions which shall apply shall be as follows. Which shall apply? They are enumerating the provisions, that's all, Madam.
the next after that is what are the modifications?
Yes,
Or what is omitted. So
that's right.
mostly they are modifications, but some are omissions.
Yeah.
For example, in part 19, if you see,
Yes, I have it.
Article 362 and 365 are omitted.
Omitted, yes.
366 clause 21 will be omitted.
Omitted, correct.
Otherwise, the whole of part
Will apply.
19, other than this will apply.
That's right.
The approach is instead of going provision by provision and enumerating 395, they went part by part. And they said this whole part applies subject to.
But
But
ultimately,
what about those parts which are not specified as parts?
They don't
they
apply.
don't apply.
No, that is the problem.
That's-
I'm not sure you're right on that.
You may not be right on that.
We have, in fact, in volume 1, we have the Constitution of India as applicable to Jammu and Kashmir, which shows that this is how it was.
Part 4 won't apply.
No, not at this stage. Not at this stage. Part 3 did not apply till 1954. Preamble did not apply till 1954. That's exactly the way they proceeded.
But that's the only.
And this is significant.
I think 15.
PDF 15. The part your lordships are referring to is?
If everything applies.
Yes.
Why were they specific?
Yes. So part 4A is omitted at that stage. 4A came later anyway, but part 4.
The one way to look at it is part 4 will absolutely apply, of course, but without any modification. But
That, with
where
respect,
there is
that's not the
modification, then
understanding-
specify.
That's not the understanding of the government of India then. That's not the understanding of the state of Jammu and Kashmir then. That's not the understanding, Malad, of any authority. Then, Malad, now we are saying, no, that was all wrong. Actually, everything
We're
applies.
not saying, we're just
And they don't,
discussing.
and you don't need consent.
Mr. Sibal, as I see it,
Yes.
every order
Yes,
extended different parts of the constitution
that's right.
to Jammu and Kashmir. Now, if a particular provision is with modification, it says so. Now, it may be by provision wise,
Yes.
or it may be part wise,
Yes,
it may be by any method,
correct.
but it keeps on extending by the
Yes,
orders
yes.
which are passed.
Yes.
So first one was provision wise in a sense. This one is part wise because practically the whole part was to apply
Yes,
with certain modifications.
that's correct.
To the extent that it is not to be applied, it is excluded.
That's right. That's the only submission. That's the only, and in any case, Malad, 1 and 3 are, 1 and the 370 are excluded.
That is from because of the first notification, separate clause C was made.
That's correct.
Clause C was made for Article 1.
So, Malad, this argument then doesn't take us anywhere because we are dealing with 370. We are not dealing with any other part of the constitution. So we can, Malad, interpret the orders any which way you want, but it cannot touch 1 and 370.
The two major points to my mind are this. One is your submission that Article 370 has acquired a permanent feature of the Constitution.
Yeah.
That's the debatable issue.
That's
which both sides will debate. Next is suppose it is not permanent. Then what is the manner of abrogating Article 370? Is that procedure followed or not?
That's correct.
The only two issues as I
Correct,
see it
correct,
in the
correct.
whole
But
issue.
I'll hope and try and convince you that it is permanent. I will try and convince you. I know, Malad, your lordship says it's debatable, and it is debatable. There's no doubt about
So
it.
both things are debatable means both sides will argue this
Yes,
point out.
it's really debatable. But I tell your lordship, Malad, why it is permanent. Malad, now, for the moment, Malad, because we have only dealt with the Constitution of India.
Debate will also be on the second point. I look at a debate whether
Of course.
the procedure has been followed or not followed. They will say we followed the manner of abrogation.
Absolutely.
You will say not.
Now, Malad, so far I've only referred to provisions of this Constitution. But Malad, your lordships will have to look at the Constitution of Jammu and Kashmir, because that Constitution, Malad, was framed and cleared in 1957. So, Malad, Parliament could only exercise, if it takes over under 356, declares an emergency, it can only exercise the powers of the legislature. That's what Bomai has said, and I take your lordship, you can't do anything more than that, right? Now let's look at the provisions of the J&K Constitution, which will give you an idea as to why it's permanent. Yeah, Malad, I'm sorry, my understanding is right. Before we go to that, let's kindly see the volume 1, PDF 132. What date is
You are wanting us to go to PDF 1 now.
PDF is the date.
Volume 1 page, Mr. Siddle.
Malad, volume 1, page 131. 132, Malad. Now, Malad, kindly see, this is the Constitution of India as applicable to Jammu and Kashmir just before abrogation of 370. And you'll see
Sorry, Mr. Simple, which page?
page PDF 132.
In the same volume?
Yes, volume 1. Volume 1, Malad, not 3. One second. Now, Malad, your lordships will see the table of contents at page 43 first.
Which page? You said 132, 43, which one?
Sorry, 43 first. Well, it's a table of contents are set out.
It will take a little longer to get to it.
Sorry, Malad. Sorry about that.
It's our fault, Malad. We are wrong.
Page 46 or
43, where the contents, volume 1,
Yeah.
looks somewhat like this.
There's one
The
little
Constitution
improvement
of
which we have
India.
to make in our written submissions format. In fact, I'm just in the process of issuing a standard operating procedure for filing written submissions on all matters before CB, which is that the index should be hyperlinked. So that'll be much easier for all the
Yes.
lawyers and for us also. We go to the index and just click on the hyperlink there.
43 is what you're saying?
Yes,
Yeah.
the index.
46 is the index.
Yes. Now, kindly see, Malad.
Index actually starts earlier. Index starts from page 43.
Yes, 43. No, 43. Your lordship has that?
Part 4 doesn't figure in it at all.
Yes. And there's no order omitting it.
This is which year?
This is just before 370 was abrogated.
It's taken from a book of 2016, but it's as it stood there.
Now you see here, Malad, after part 6, you have part 11.
Part 6, what page is that, Mr.
Well,
Subal?
part 6 is at page PD 48, PDF 48. And the next is, yes. Part 11 is page 49. So nothing is excluded. There's no specific provision. Therefore, the order says provisions which shall apply shall be as follows. That's why, Mother, the 54 order says what it says. Provisions of the Constitution which shall apply.
So notwithstanding the deletion of the word only,
Yeah.
the word which seems to indicate that these are the
That
parts, the
really-
provisions which will apply.
So that's, Mullahs, really. Now, Mullahs, in this context, kindly look at the Constitution of Jammu and Kashmir as it was cleared in 1957, passed in 1957. And remember, Mullahs, yes, right.
Publication or government publication?
It's not a government publication, Mullahs, but this is not hopefully not in dispute, Mullahs.
But Mr. Sibal, you are right that the constitutional practice which was followed since the adaptation orders proceeds on the basis that government selectively applied provisions of the constitution to Jammu and Kashmir. They never treated it as if all provisions apply. Though really clause D is susceptible of two interpretations, but the constitutional practice supports what you are arguing. We'll of course have to hear the learned AG on that.
Now, Mullahs, we move on to what happened in 1957 when the Constituent Assembly, Mullahs, drafted this constitution and was adopted. Right. And Mullahs, remember the 1954 order came when the Constituent Assembly was there. They had a choice. They could have said, no, we want.
57, what happens at 57? Let's see then. For
Yeah, but I'm
57.
just saying the Constituent Assembly was constituted in 1951, I think on the 10th of May, if I remember correctly. And then, Mullahs, 54 order was passed. They could have said, look, no, we'll abrogate 370 and be part of India without conditions and like any other state. They chose not to. And you will see that, Mullahs, in the Constitution itself. I'll show, Mullahs, it's better we look at the
There
Constitution.
is no dispute about the proposition. 370 remained in the Constitution.
Yeah.
So nobody is arguing that 370 was not there. Otherwise, where was the occasion to abrogate it? Only issue is whether it requires a permanent character, which cannot be touched, or whether there is a methodology, right or wrong, there is a methodology by which 370 can be abrogated.
Correct.
That's the first part of your argument, as I understand.
Correct.
And in the alternative argument is, even if you don't accept my first part of the argument,
The methodology was
the
wrong.
methodology was wrong.
Sir, I'm sorry to interrupt, but on this permanent statement, 370 is in three parts. The first part, our argument is continues always. Second part is transitory because it's dealing with what happens before the Constituent Assembly comes in and Constituent Assembly has to ratify. The third part is temporary while the Constituent Assembly is there. Just putting it in a nutshell, that's our argument.
Yes, you are saying, according to you, 370 is structured in a manner
Yes.
whereby some part will go away or become
Yes.
otiose, and some part becomes otiose because in 1957, some
Correct.
other part becomes otiose
Correct.
later on. So you say one has a permanent feature. That is your
So the
argument. you
Constituent
want to-
Assembly effectively had a choice to exercise three or to allow one to
Till
continue forever.
1957. Your argument is all these choices were available only till 1957.
Yes, that's a.
That is your argument.
So, but, no, let's not debate it.
In fact, that's why the explanation to B contains an exhaustive definition of what is meant by the government of the state. Government of the state does not say includes the Maharaja. It says government of the state means the person for the time being recognized by the president as the Maharaja of Jammu and Kashmir,
Correct.
acting on advice of the Council of Ministers for the time being.
Right.
Now, what happens when the Maharaja is replaced by an elected government in Jammu and Kashmir?
Then the elected government on the aid and advice of the Council of Ministers.
Where do we
Governor-
get that? Because the explanation says government of the state means.
Well, I'll show that to your lordship. That's also there, madam. It is part of the constitution, madam. I'll show that.
This explanation was introduced in 1952. This ex-
There's a difference of opinion here.
Leave it. Let's, you can.
Their case is that 2 and 3 may cease post 57. But some of us whose argument is that no, the entity goes if we read clause 2 carefully. So this is that difference of opinion. So your submission.
Well, there is a government order of 1965 which says that Sadr-e Riyasat will be in the governor.
67.
Yes, 1965 order.
65. So till 65, did the Maharaja continue to have?
Yes, madam. Then,
There were
for-
separate powers of Sadr-e Riyasat.
Yes.
The
but madam, ultimately,
equivalent of chief minister was called the prime minister.
Yeah,
for a
that's
long
correct.
period of time.
But
till
in
those
65, madam,
terminologies
it was the
were,
governor.
removed.
There's an order to that effect. So be that as it may, madam, I think we're traveling a bit too far at the moment.
It's not anything that was done under the 70s.
Now kindly see, madam, the preamble of the constitution, your lordships will find volume 2, PDF page 16.
Now we are looking at the J&K constitution.
That the Constitution of India is applicable under J&K Constitution. J&K Constitution.
So that is volume.
Volume 2, PDF page 16. Yes. No room for J&K.
You want us to go to page 16 of the
Page
J&K
16. Yes, the entire volume is that. Lordship has the preamble. Still 65. Still 65. There was an order in 65. Just kind of page 5, PDF page 5, volume documents, volume 2. Just it's the index, Mullahs, really. Right. Right.
So you referring to preamble at page 16.
Yes, but before that, Mullahs, just so that you know Mullahs, what the Constitution was dealing with.
Page 5 is part 3, you are saying.
Page 5.
You're wanting us to read page 5?
Contents, Mullahs. Contents. The state, permanent residence, directive principles,
that's what I'm
state
saying.
policy. PDF 5.
Yes.
Just the contents, Mullahs. Yes. You see now, part 1, part 2, part 3, part 4. And the directive principles of state policy now come in. Permanent residence come in. Then the state, permanent residence, directive principle of state policy, executive, governor, council of ministers, advocate general, contractor, government of business, composition.
Just 1 minute, Mr. This goes against Speaker's directive.
Officers of the state legislature, disqualification of members. It's really a replication of what the Constitution, our Constitution provided. Procedure for financial matters, legislative power, high court, subordinate courts, finance, property, public services, elections, amendment to the Constitution. This is very important. I show that to your lordships presently. And then the schedules, speaker, deputy speaker, and all that. Now kindly come us to the preamble. PDF page 16. So we, the people of the state of Jammu and Kashmir, now the Constituent Assembly exercise its powers. Drafted the Constitution, adopted. We, the people of the state of Jammu and Kashmir, having solemnly resolved in pursuance of the accession of the state to India, which took place on the 26th day of October 1947, to further define, this is important, to further define the existing relationship of the state with the Union of India as an integral part thereof. That's Article 1. And to secure to ourselves justice, social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among us all, fraternity, assuring the dignity of the individual and the unity of the nation. In our Constituent Assembly, this 17th day of November 1956, do hereby adopt, enact, and give to ourselves this Constitution. Now kindly see the definition clause. In this Constitution, unless the context otherwise requires, the Constitution of India means the Constitution of India as applicable in relation to the state. Right? Then kindly come to Muller's Article 3, the state. Relationship of the state with the Union of India, the state of Jammu and Kashmir is and shall be an integral part of the Union of India. And Muller's subclause 3 says, just above that, any reference in this constitution to the Sadr-e Riyasat shall, unless the context otherwise required, be construed as reference to the government. This is 1960, which my lord was asking that question. So, it shall be an integral part of India. And then 5, Article 5, the executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. Then, Millets, the issue of permanent residence is dealt with. We're not concerned with that so much. And then you come to 35, page 28, PDF 28. This is an important section, Malaj. Important article. 35. My lords have that. PDF 28. Council of Ministers to aid and advise the governor. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions. All functions of the governor, except those under sections 36, 38, and 92, shall be exercised by him only on the advice of the council of ministers. So other than 36, 38, and 92, Malaj, he will act on the aid and advice of the council of ministers. Now kindly come to 38, 48A, PDF page 33. This was inserted, Malaj, in 1975.
Yeah.
Is notwithstanding anything contained in this constitution, if upon the completion of a census, but before the final readjustment of territorial constituencies, the Legislative Assembly is dissolved prior to the expiry of its duration, and the governor is satisfied that holding of general elections without delay is necessary, he may, after consulting the Election Commission by notification, direct that the general election shall be held on the basis of the last preceding delimitation of territorial constituency. Then let's page Article 53, page 37, PDF 37.
Article
53, Malaj, at PDF 37. That's the session of the legislature, prorogation and dissolution. The governor shall from time to time summon each house of the legislature to meet at such time and place as he thinks fit. But 6 months shall not intervene. These are the provisions of the Constitution also. Intervene between its last sitting in one session and the date appointed for its first sitting in the next session. The governor may from time to time prorogue the houses or either house or dissolve the Legislative Assembly. This he can only do it on the aid and advice of the Council of Ministers. It's not an exception because the exceptions are 36, 38, and 92. This is important because it really, the issue will arise because Malaj, there was no Council of Ministers when he did this, which is on the 21st of November, 2019. 2018. Well, the importance of this is that he can only dissolve the Legislative Assembly on the aid and advice of the Council of Ministers. The only exceptions that the governor has in the terms of his exercise of power are 36, 38, and 92, which he need not do on the aid and advice. But under 53, he can't do it without the aid and advice, which is what he did. Well, I'll come to that later. Now, Malaj, 92, which is that exception. PDF page 59. This is a very unique power given to the governor of Jammu and Kashmir. Yes. I was mentioning, Millet, as far as 53 is concerned, that power to dissolve the assembly would only be exercised on the aid and advice of the Council of Ministers. So when he dissolved the assembly on the 21st of November 2018, he didn't do it on the aid and advice. And this governor's power has to be exercised in that fashion. The only exceptions are 36, 38, and 92. And I'm now reading 92 for your lordship. This is also a unique provision. Provisions in case of failure of the constitutional machinery in the state. This is PDF Mullahs 59. My lords have that. Does this call, Mullahs? Does your lordship have one?
Page 50.
59, PDF 59, Article 92. My lord have it.
Breakdown of.
Yes. Now, provisions in case of failure of the constitutional machinery, if at any time the governor is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution, the governor may by proclamation, Mullahs, assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by any body or authority of the state, make such incidental and consequential provisions as appear to the governor to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this constitution relating to anybody, provided that nothing in this section shall authorize the governor to assume to himself any of the powers vested in or exercisable by the High Court. We are not concerned with that. But this he can exercise without the Council of Ministers, unlike in the Constitution of India. Why? Because Jammu and Kashmir has a unique status in the context of its relationship to the government of India. Yes. Huh? And Miller's clause 3 of this is important, that any such proclamation, whether varied under subsection 2 or not, shall, except where it is a proclamation revoking a previous proclamation, cease to operate on the expiration of 6 months from the date on which it was first issued. So, Maharaj, the proclamation was issued on November 21st, 2018, on 20th of June. It was to expire in 6 months' time on 19th December. And Maharaj, on November 21st, he dissolved the assembly. And without reference to the Council of Ministers. But anyway, we'll come to that a little later. Now, most important, is in the context of what we've been arguing all of yesterday and today, is 147, PDF 85, sorry. No, sorry.
Amendment to the Constitution.
Yes. Well, an amendment of this Constitution shall be initiated only by the introduction of a bill for the purpose in the Legislative Assembly, and when the bill is passed in each House by a majority of not less than 2/3 of the total membership of that House, it shall be presented to the Governor for his assent, and upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. Provided that a bill providing for the abolition of the Legislative Council may be introduced in the Legislative Council and passed by it by a majority of the total membership of the Assembly and by a majority of not less than 2/3 of the members of the Assembly present and voting. Provided further that no bill or amendment, now this is important, provided further that no bill or amendment seeking to make any change in this section or the provisions of sections 3 and 5 or the provisions of the Constitution of India as applicable in relation to the state shall be introduced or moved in either house of the legislature. So, Maharaj, you cannot amend 370, as it is made applicable to the constitutional order made applicable to the state of Jammu and Kashmir. So no legislature can even move a bill. This is what makes it permanent. This is exactly why it is permanent. It had to be temporary because at that time there was no constituent assembly. It was temporary, it had to be temporary. Per force it was temporary. Even 3 cannot be amended. Section 3 cannot be amended.
But can the permanency of Article 370 be a consequence which follows from the Constitution of Jammu and Kashmir?
No, it's made applicable to Jammu and Kashmir by an application order.
No, but you're saying that this provision,
Yes.
Article 147 of the J&K Constitution,
Yes.
makes Article 370 permanent. Can the permanency of the Indian
Yes,
Constitution?
because, brothers, kindly see, the 370 was made applicable to the state of Jammu and Kashmir by an application order. 373, brothers, kindly. Subclause 3 gives powers to the Constituent Assembly, no?
Those powers clearly
Those-
doesn't have.
That legislature doesn't have those powers. Country middle, what happens is when you impose Article 356, you took over the powers of the legislature. Under which power did they exercise that right?
Not of the legislative assembly.
Yes, exactly. That's what I'm saying, Malak.
Mr. Sibal, how
But then
can
how
we,
is proviso C will applicable?
Yeah.
how can, you are saying Article 147 gives the permanency to Article 370?
Because the Constituent Assembly, I'm sorry, I shouldn't interrupt you.
Now, can the Constitution of J&K give a permanency to Article 370 of the Constitution of India?
Exactly.
But that's all we are saying is that the Legislative Assembly does not have the power under 370 subclause 3. That's all that I'm saying, nothing more than that.
What you're saying is Legislative Assembly cannot exercise the power and the proviso to clause
Yes,
C,
yes,
clause 3
yes.
of
So
Article
what,
370.
then
That's
what,
not-
that's why they did, they converted the Legislative Assembly into the Constituent Assembly. That's what they did, Malak. This is what is shocking.
The lighter side, the Parliament did it.
I'm sorry?
On the lighter side, the Parliament did it.
Yes. So Parliament converted itself into the Constituent Assembly of the state. I mean, it's unheard of. Yes, no means, but we'll show it. We'll show it. We'll demonstrate that. At the moment, all I'm saying is, Malas, you cannot exercise, the legislature cannot exercise powers to amend 373. Yes, even some other body takes over those powers, that only powers can be exercised is the powers of the legislature, nothing more than that. The whole scheme of 356 is if you take over.
The Parliament can do it or not.
Yeah, well, Parliament exercises the powers of the legislature under 356. It can't exercise any other power. And that's the scheme of 356, which I'll come to later. That's Bomai, mothers. Now that's settled. You can't arrogate to yourself a power that the legislature doesn't have. That's why there's an interplay between the Constitution of India, the Constitution orders applicable to the state of Jammu and Kashmir, and the Constitution of Jammu and Kashmir and 370 itself.
That's what you flagged in the beginning when you began your speech.
That's the issue.
Actually, Article 147, the second proviso to Section 147 of the J&K Constitution, would seem to indicate that the provisions of the J&K Constitution are treated to be subordinate to the Indian Constitution. Which is why no amendment in the relationship of the Indian Constitution and its application to the state can be introduced in the state legislature. The state legislature cannot change that relationship.
Correct, but I'm not disputing that. It is the legislature cannot introduce a bill to that effect. And what's the procedure? Only under 370. It's only under 370, Manoj.
But this is in that sense a subordinate instrument in its application to the
Well,
in its
it's a
relationship to the
subordinate-
Constitution of India.
But let's kindly see, one second, kindly see, just 1 minute. Kindly see, the Constituent Assembly has now framed the Constitution. The Constituent Assembly has not exercised the power that it had, Manoj, to abrogate 370. In that process, the Constituent Assembly, when drafting the Constitution, decided that nobody can change that status. The legislature cannot change that status. Now, whether Parliament on its own can change that status is a separate issue, but the legislature cannot change that status. That's the element of permanency as far as the legislature is concerned. Let me put it that way.
The legislature has no authority to change the relationship between.
That's correct.
That's what
Legislature
you're
cannot
saying.
change. Why? Because this is not a temporary provision. Come to that. That's clear, Manoj. Section 3. Same thing. Section 3. The Legislative Assembly also can't touch below the provision that the state of Jammu and Kashmir and shall be an integral part of India. Section 3. It also can't touch extent of executive and legislative power of the state. Can't touch that. And it can't touch 370. So from the point of view of the Constituent Assembly, when the legislation was drafted and the Constitution was drafted, it was clear that this relationship is permanent.
Just one question, the proviso to Article 147 of the J&K Constitution
Yes.
says that no bill or amendment seeking to make change in the provisions of the Constitution of India is applicable
Yes.
in relation to a state
Yes.
means a change in the Constitution of India. Whereas, as per clause 3 of Article 370, it's not the amendment which is applicable. As per that, it's the consent or the consultation or the,
Recommendation. Neither consent nor consent. It's a recommendation
no. if
of
we-
the
Let's
of
see
the Constituent
373.
Assembly.
Let's see 373 for a
Yes,
minute.
please.
So really speaking, under 147 may have no application as far as, because you're not seeking to amend 370, but enforce 370. Let's assume, for the time being, substitute the words Constituent Assembly for Legislative Assembly. On the recommendation,
Yeah.
let's assume so.
Let's
Substitute. You're right,
Correct.
recommendation.
correct.
Let's substitute that word, provided that the recommendation of the Legislative Assembly or the state referred to shall be necessary before the President issues such notification.
Yeah.
So really, 147 will not be applicable in case the state legislature makes that recommendation.
No, but let's kindly see what 147 says is the provisions of the Constitution of
But
India
you're not
as
amending the.
applicable in the relation to the state.
You're not amending the Constitution. You're not amending this Constitution of India. Let's, for the time being, let's read as it is, because what is barred under the proviso to 147 is amendment seeking to make a change in the provisions of the Constitution of India.
As applicable in relation to the state.
As applicable in
Which
relation
is,
to the
which is
state.
why 370 is incorporated, Malad, in the Constitution of Jammu and Kashmir. As it stood then, that's the application order.
Mr.
We're
Sibal,
not talking about the Constitution of India here.
Sibal, doesn't it, I'm just thinking aloud,
Yes.
does it not mean that the proviso, the implication is that once the provisions of the Constitution of India are made applicable by different orders,
Yes.
you through an amendment cannot
That's all
deactivate
that
it?
we are saying. Nothing more.
Can deactivate a provision which has already been applied to the
Yes, yes.
Constitution
That's all that we are saying.
of,
Nothing more than that. We're not amending the Constitution of India. We're amending the constitutional order applicable to the state of Jammu and Kashmir, which makes 370 applicable. And it can't even be moved in the House. Yes. And if it can't be moved in the House, it can't even move the bill. It can't be moved in Parliament.
as I see it, it's that you can't go back. Suppose after consultation, the CO has been issued, order has been issued, notification has been issued, certain provisions of the Constitution have been made applicable.
Yes.
Then it's not that a rethink can arise 10 years later and you start
That's all. That's all.
and say that, look, okay, we don't want to make some of the Constitution provisions
Absolutely.
already made applicable,
Correct.
not applicable.
So my argument is that the Constituent Assembly has exercised its choice. And it's evident from the provisions of the Constitution itself. So you need to read the Constitution of India, the orders applicable to Jammu Kashmir, the Constitution of Jammu and Kashmir, and 370. So under what provision of law under the Constitution of India can you change that? When you are doing it under 370, 356. So now, Malaj, this is now the lay of the land as far as this is concerned. Now I want to take your lordships to the judgment of Supreme Court, Malaj, of this court in the power of the constituent Keshav Nand, Malaj. Volume. This is it. T. No, no, no. When that comes up. Let me have this constitution.
So, Sipal, is the factual whatever you had to say is over?
No, no, Maharaj, I'll go back because we are on the point of the Constituent Assembly and the Legislative Assembly. So Maharaj, that has to be clarified. Maharaj, you can't, a Legislative Assembly cannot be converted into a Constituent Assembly. My basic argument is that. Under what power can you convert a Legislative Assembly into a Constituent Assembly? Which is that power?
As a matter of fact, Praja Sabha was turned into a constituent assembly, 1951.
Well, there was a direct election, I believe, Maharaj, at that point in time. Rajya Sabha was not all directly elected. But I'll check that out, but I don't want to make a statement and I'm sure of it. No, 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 there was not. I mean, I don't want to, Maharaj, give an answer without being sure of it.
Unless you are sure about it.
That's right, Maharaj. I always hesitate to do that, Maharaj. My learned friends are far more, articulate on those issues, Maharaj, than I am.
Seized by the Raja. 2051. Just about by the power of Rajya Sabha was conferred to the Constituent Assembly.
The power of constituent assembly was conferred on the Praja Sabha.
Maharaj, according to me, and I'll give that date, why should I, Maharaj, say anything? The Constituent Assembly was directly elected in Jammu and Kashmir, but I don't want to, Maharaj, I must be sure of it before I say that. I know, it says that Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution. So I was aware of it, Maharaj, but I was not sure where it was. I just wanted to mention. Unlike Unlike us, we were indirectly elected, our constituent assembly. Anyway, let's kindly have a look at Keshavnand Bharati. This is volume 15. Volume 15 of
Yes, that's a good idea.
Case Law Compilation, PDF 236. Actually, 235. I'll start with paragraph 537. Volume 15, my lords. Volume 15, paragraph 537. Which is why I've been saying throughout my submissions, this was a political act to achieve a certain political purpose, dehorse the provisions of the Constitution. Page, my lords, 235, paragraph 537.
We've got it on the screen as well.
Yeah.
Sorry, Mr. Sybil, sorry. I just wanted to answer my Lord Justice Gavai's question. I just sought to be unmuted. My Lord, there was a proclamation by Yuvraj Karan Singh for constituting the Constituent Assembly on 20th April 51. It was elected by adult suffrage. This was convened on the 31st of October 1951, its first sitting, and Melody concluded its work on the 17th November 56, when it decided to adopt the constitution on the 26th of January 57.
That's correct. On this page, para 537 of PDF 235.
Whose judgment is this?
This is Malad's Justice Shellett and Grover. Well, the argument was that
Which page are you number?
368 refers to procedure to
You are
amend the
referring to
Constitution.
page number?
Page 5, PDF 235.
235.
Volume
235.
15, Mr. Sibbal.
I'm sorry,
Volume 15.
volume 15.
Case law compilation.
Volume 15.
Case law
Case
compilation.
law
Lordship has that?
No, we have got something else.
Page 235.
It's with you, huh, Billy? In case you want to see it on the screen.
Create.
We've got it on the screen.
537, 538, Mullahs. I just read 37. The argument was, Mullahs, that when the Constitution in 368 talks of amendment to the Constitution, it's a procedural argument. Where does the constituent power lie? That was the argument, and that in that context, the issue of what is a constituent assembly,
Yes.
that is discussed, Mullahs. It's in that context because we're dealing with that issue. 537, if I may read. It is pointed out on behalf of my lords, all my lords have
Yes.
it. It is pointed
I
out
just
on
got
behalf.
it. You got it? Oh, yes.
It is pointed out on behalf of the petitioners that the scheme of Article 368 itself contains intrinsic pieces of evidence to give a limited meaning to the word amendment. Firstly, 368 refers to an amendment to the Constitution, and the result of the amendment is to be that the Constitution shall stand
One
amended.
second.
No. Yes, 235. My lords have it, my lords, not yet.
No problem.
constitution of its identity. The amending power is conferred on the two houses of parliament, whose identity is clearly established by the provisions of the constitution. It must be the parliament of the sovereign democratic republic. It is not any parliament which has the amending power, but only that parliament which has been created by the constitution. In other words, it must continue to be the parliament of a sovereign and democratic republic. The institution of states must continue to exist in order that they may continue to be associated with the amending power in the cases falling under the proviso. If the respondents are right, the proviso can be completely deleted, since Article 368 can be amended. This would be wholly contrary to the scheme of Article 368 itself. Scheme of 68, because two agencies are provided for amending the provisions covered by the proviso. One agency cannot destroy the other by the very exercise of the amending power. The effect of limitless amending power in relation to amendment of Article 368 cannot be conducive to the survival of the Constitution because the amending power can itself be taken away and the Constitution can be made literally unamendable by virtually unamendable by providing for an impossible majority. While examining the above contentions, it is necessary to consider the claim of the respondents that the amending power under 368 has the full constituent power. It has been suggested that on every occasion the procedure is followed as laid down in Article 368 by the two houses of Parliament and the assent of the President is given. There is the reproduction of the functions of a constituent assembly. Just mark. In other words, the Parliament acts in the same capacity as a constituent assembly when exercising the power of amendment under the said article. This is fundamental to the entire argument that I'm making. In other words, Parliament acts in the same capacity as a constituent assembly when exercising the power of amendment under the said article. This argument does not take stock of the admission made on behalf of the respondents that the entire Constitution cannot be repealed or abrogated by the amending power. Indisputably, a constituent assembly specially convened for the purpose would have the power to completely revise, repeal, or abrogate the Constitution. That shows that the amending power under 368 cannot have the same powers as a constituent assembly. Even assuming that there is a reference on the nature of the power being enacted between enacting a law and making an amendment, both the powers are derived from the Constitution. The amending power has been created by the Constitution itself. It can only exercise those powers with which it has been invested. And if that power has limits, it can be exercised only within those limits. So you have a clear distinction between the exercise of constituent power and the exercise of legislative power, which is what I said in the beginning to your lordships. Parliament, while enacting a law, functions within the contours of the Constitution. A constituent assembly has no constitution in place. It has every right to do what it likes till such time as the Constitution is framed. So at no point in time in law can a legislative assembly be converted into a constituent assembly as a matter of law. Yeah. Luckily, we had no Maharaja exercising his powers with us. We had Parliament doing that. Now,
even when Parliament amends the Constitution,
yes,
it's not exercising powers as a constituent assembly.
that's correct.
It may be exercising a constituent power,
That's correct.
the power to amend, but because it's a power which is restricted, You are subservient to the Constitution.
That's right.
And therefore, you're bound by the provisions of the Constitution, by virtue of which your power to amend the Constitution is circumscribed.
That's what I said at the outset, Malas. That has been my submission throughout. Now, the next paragraph, Malas, is paragraph 620. This is at PDF page 273.
Whose judgment is that?
This was Justice Hegde and Justice Mukherjee.
270?
Malas, 273 PDF, para 620 minutes. Otherwise, Malas, see the danger of this argument. Tomorrow, Malas, Parliament says that we are the Constituent Assembly. They can do away with basic structure.
Dr. Ambedkar also spoke about it in his speech on 25th of November, 1949.
I'm sorry, I didn't get your note.
Dr. Ambedkar,
Yes,
while presenting the final draft
yes,
on 25th of November 1949,
yes,
also spoke about this aspect
yes, yes.
in his
Yes, I
concluding
think
speech.
we have it, I think. We have it, I think, in volume 8. I just come to that. No, the point I'm making is a more fundamental point which impacts the future of our country. If you in principle say that a parliament can convert itself into a constituent assembly, then where do we go from there? Forget about this case. I'm far more worried about our future. Parliament can never say that, because that constituent assembly is a political process, which I said at the beginning. It's a political process in the context of the aspirations of all those participating in the constituent assembly as to what the state should be like. How do you meet the aspirations of the different segments of the community which have to be met, and what kind of provisions should be put in place? So it's the genesis of the politics of the day which determines what kind of constitution we want. Which is why, when you talk about diversity, when you talk about minorities, we talk about Dalits, we talk in our constitution, what were we faced with? In 1947, what were we faced with? We were faced with a situation where disparate communities, diverse communities, different religions, different races came together to be part of the Union of India, and their aspirations had to be met. So you had provisions for the Dalits, you have provisions for the minorities, you had provisions dealing with reservations, the scheduled castes, the scheduled tribes. That's a political process. That's why our constitution is what it is. Unlike, as I told, in Europe, it was an entirely different process. Here it was an amalgamation of colors to be united as one, which is the Tiranga. That's what it is. You can't convert a legislative assembly into that process.
But equally, Mr. Sibal, to completely divorce the power of amendment from the political process inherent in the amending power,
Yes, of course.
would not be appropriate, because there's no strict dichotomy in that sense between the exercise of the constituent power itself being traceable to the political process and the power of a constituent assembly being entirely political in its nature. The constituent power itself of Parliament to amend the Constitution is a political power.
I agree entirely. Absolutely right. We're not saying you can't amend, because it's not our case. You can.
But when Parliament amends according to you, it is not exercising the powers of a constituent assembly.
That's all that I'm saying. That's all that I'm saying. It's not converting itself. And then it has to function within the Constitution of India. I'll come to that later. We're at a stage, Malad, where a CO is issued.
The Constituent Assembly is untrammeled.
That's right.
It's as if it is working on a clean slate.
That's correct. Absolutely. Absolutely, Malad. And it says, the judgment says so, Maharaj, that it's not bound by anything. Bound by the representatives of the Constituent Assembly who have common aspirations to draft a constitution for the future of the people of the country. Which is why diversity, protection are fundamental to our constitution. For this reason, this very reason. So you want to take away that, that's very dangerous. I'm not being political, but that's the worrisome part. I reach 6:20 minutes.
20.
Now, coming back to Article 368, it may be noted that it has three components. Firstly, it deals with the amendment of the Constitution. Secondly, it designates the body or bodies which can amend the Constitution. And lastly, it prescribes the form and the manner in which the amendment of the Constitution can be effected. The article does not expressly confer power to amend. The power is necessarily implied in the article. The article makes it clear that the amendment of the Constitution can only be made by Parliament, but in cases falling under the proviso, ratification by legislatures of not less than one half of the states is also necessary. Normally, if you read the proviso, if you don't have the ratification, there'll be no amendment. You can't wish away the proviso. That article stipulates various things. To start with, the amendment of the Constitution must be initiated only by the introduction of a bill for that purpose in either House of Parliament. It must then be passed in each House by a majority of the total membership of that House, and by a majority of not less than 2/3 of the members of that House present and voting. And if the amendment seeks to make any change in the provisions mentioned in the proviso, it must be ratified by not less than one half of the state legislatures. Thereafter, it should be presented to the President for his assent. It further says that upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. To restate the position, Article 368 deals with the amendment of the Constitution. The article contains both the power and the procedure for amending the Constitution. No undue importance should be attached to the marginal note which says procedure for amendment of the Constitution. Marginal note plays a very little part in the construction of a statutory provision. It should have much less importance in construing a constitutional provision. So, Mullahs, when your lordships talk about temporary, Mullahs, really you have to look at the Constitution. Because it had to be temporary in 1950. There was no element of permanency. It could not have been. And this is the marginal note. Give it to my lord. Do you have copies?
This is a marginal
Give it to
note.
the
There's
other
no
side.
question about it. It is a marginal note.
Yes. So, Mullahs, you can't be saying, which is what your lordships are concerned with, but it was temporary. But that's only when you look at the marginal note. It had to be temporary because there was no other way to deal with it. You couldn't have said it is permanent.
There's no doubt still about the fact that this forms a part of Part 21 of the Constitution, which still deals with temporary and
But those
special
are
provisions.
I'm not disputing that. These are all different provisions, Mullahs.
They've all been clubbed together in Part 21.
That's correct. But we looked at it in the context of, Mullahs, what was going to happen in the northeastern regions. Gujarat and Maharashtra together, what was to happen there, issues of Marathwada. So those councils had to be created, boards had to be created. That's why they were temporary. Telangana, that's why they were temporary. Not for any other reason. And that's why this was also temporary. It's the same logic. But the fact that it is temporary doesn't mean that the article is temporary for all time to come. You can't interpret the marginal note in that fashion. So the language of 368 to our mind is, I'm sorry.
317, is it actually good? Yeah, actually, they put क्या उन्होंने?
If you look at the heading, Millers, it says temporary and transitional provisions. So 2 is temporary and 2 is transitional and 3 is temporary.
It's 368 power, right?
In this case, no, 356 power. No, it's 356 because they converted. What happened? Well, let me just in one sentence. They say, in one sentence, I'll tell you what they did. They converted the Legislative Assembly into the Constituent Assembly. Right? Right, dissolved. They converted it into a Constituent Assembly. Then they said that now Parliament, because of 356, Parliament is exercising that power. So the Parliament is the legislature. And because it's a Constituent Assembly, Parliament of India is the Constituent Assembly, and therefore we can do what we do. That's in one sentence what they did. And they recommended to themselves. So instead of clapping by 2 hands, they clapped by 1 hand. Because they exercise the power of the legislature themselves. And because the legislature's consent was necessary to give that consent to themselves and abrogated 370. Unique, constitutionally a unique, unheard of. I will not use that expression. A procedure that is unknown to law. Because the objective was entirely different. And I've been saying that from day one.
That's how they brought in the
10 minutes. Yes. 7 is a different issue. It's on the definition. I don't think so. Discuss that.
to apply the proviso to clause 3 of Article 370.
Yes, yeah, because they understood it that way, that it required the previous.
And then what they do is they say that the Parliament exercising the powers of the Constituent Assembly
Yes.
by virtue of the fact that the Legislative Assembly has been dissolved.
Yeah.
assuming that the Legislative Assembly was not dissolved, that could have exercised the power of the Constituent Assembly.
That's right.
Now that it has been dissolved,
Yes.
under 356, Parliament has the power to make laws with all aspects of whether it's
Correct.
list 1, list 2, or list 3. And then they exercise the power under the proviso.
That's right. That's right. So, Malad, actually, they understood 370 sub-article 3 in the manner in which I am, Malad, stating before your lordship. It is their understanding right till the end. They don't understand. Which is why I wanted to bring it at this stage, Malad, so that now your lordship knows, Malad, the larger picture, so to say. So we are going into interpretation of 370 sub-article 3, which they themselves accept, that the proviso applies. No, tak faham.
We'll come back after lunch. Mr. Sibal, if you can just in a very brief while, take us through the process which was followed. We can go straight to that. Now we've understood anything more in Keshavananda apart from these four judgments? All right, we'll see that and then so that we come to the end of then reading Keshavananda.
Yeah, 25th November.
And if your lordship sees the facts, I think it'll help. No
Where he
idea.
said we enter a life of contradictions. That's how he
It's about his amending powers also. In
That's
that.
right, he covers it. He covers it.
He was criticized on both the sides.
That's right.
It's too liberal and too rigid.
Obliged. Deeply obliged.